Welcome. Thank you for joining us. I think calling in from Tel Aviv, where you are Professor there, and writing extensively on constitutional law, labour law, issues of religion, democracy, all sorts of things. So it's really great to have you here joining in the discussion. So how this will work is for each panelist we'll have about 15 minutes, starting with about 5 minutes of comments, and then bit of time back and forth between David and our panelists, and see where it goes from there. So, is there somebody who would like to start us off? We haven't actually chosen a person, but anyone you particularly want?
Oh, Peter looks like he's. Peter would like to kick.
Thank you. Over to you, Peter.
I'll unmute myself. There we go. No, I always like to start off because then I can enjoy the talk better after I've done my bit. Now, what I want to do is start by quoting a sentence from a quite an old article by Professor S.F.C. Milsom, a leading historian of the English common law. And he says that legal development consists in the increasingly detailed consideration of facts. If so, the limit at any time is the extent to which the legal process presents the facts for legal handling. Now, he was writing about the shift in the common law from primitive forms of dispute settlement like trial and ordeal towards the development of proper forms of action. And while I was reading David's book, I sort of thought, my God, I think that we're actually trying to do the same thing now in a completely new field of law, in international / transnational law, and with a completely new set of questions, which in themselves raise the need to actually understand the factual issues that underlie the issues of justice that corporate responsibilities for human rights create. And at the moment, I can't think of a stronger and more sophisticated framework than what David has come up with. But I think everyone would agree it is actually a very detailed method for proper factual analysis and getting to the proper facts that allow us to understand the justice issues. And I think that is one of the important questions that we should read into the book. Now, I think I'm right in saying that because David's approach, as exemplified in today's presentation, as well as a cautious one, which is based on case-by-case analysis. Because one of the biggest problems in business and human rights is generalization. And I think that a very important theme in the book is the need to distinguish between different industries and what the problems in those industries are. For example, IT is more likely to create issues of data protection, of individual privacy and liberty, whereas, for example, a dangerous production process like the Bhopal production process is more likely to create rights to life problems and massive environmental law problems. So I think David is spot on in actually making us think in case-specific ways. Now, if I have any criticism, is that the framework is quite complicated to use. And I think one of the things that I hope to work with David on in future is focus and see how we can evolve this framework to make it a bit more user-friendly. But it's a great start. That's the first point that I want to make. Now, David knows that I've got some questions about the basis of obligation and social contract theory and its uses, but I'll skip that for now, or possibly altogether, depending on how the discussion emerges. And I just want to focus much more on the balancing issue. Now, I read David's book as not coming from a kind of anti-business or socialist perspective. There's no question that this book is still working within the liberal market paradigm. But let me be a devil's advocate for now. What if we actually look at the implications of trying to balance rights and obligations of corporate actors and human rights victims in a market-driven economy in a system which prioritizes rights to property and sanctity of contract, almost with religious zeal. Now, in that situation, can we honestly hope that the institutions of the state and the judiciary will actually be capable of objective balancing approaches? David mentions, for example, in international investment law, the Orbeza case, which was the first time that an investment tribunal accepted that a state could bring a human rights-based counterclaim in answer to the corporation's claim for breach of a bilateral investment treaty, which is great, except that on the merits they lost. The case wasn't made out. I wonder if a more detailed factual analysis would assist. But I am given at least some hope if we look at cases in the UK and Netherlands and so on, which have started to look at parent subsidiary liability in a much more creative way. But we counter that then with the demise of the Alien Tort Claims Act. So where we are in the world at the moment, I'm not entirely sure which way states and judges will jump. But again, the presence of David's framework may make people start to think analytically about how to frame these cases more properly. Now, another thing that David, you haven't seen this comment in advance, but I've just written down a couple of notes while you were speaking. Now, one of the questions that I have is, if there are autonomous human rights-based claims, which you suggest there are, and which also find an echo, for example, in the Canadian Supreme Court's decision in Nevson and Araya, where the very question of how to frame the case was quite important. Do we frame it as a tort claim or a human rights claim? Now, I wonder whether your roadmap might not give substance to the idea of the development of autonomous human rights-based claims, which go beyond the law of tort, for example. I'm agnostic about whether we could go beyond tort or whether tort is good enough. I mean, there are voices, which we all know, who say tort is the best way forward. But that's one of the things that came up. The other is, in what legal tradition is your method grounded? Because it reads to me very much common law inspired. And I'm conscious that you are from the Romano-Dutch South African system, so you are also cognizant, much more than I as a common lawyer, about the impact of civilian ideas. But I ask myself, how does this framing of cases, which is very much geared towards what lawyers in England would do to bring a case, by looking at the facts and structuring them around the causes of action that they may have. How does that work with a civilian system where you have, for example, an examining judge? I think that there's quite big questions about the technicalities of how you develop the rules of evidence in different legal systems. And it's one of the problems when we go to the international level, is it's a comparative law problem, essentially. How do we actually find a common language between different legal families for establishing, analyzing, and concluding from the various facts that are relevant? Okay, well, those are my starting points.
Brilliant. Thank you so much, Peter, for those comments. And I think, as you correctly say, I think we are in the infancy of our engagement with corporate obligations in law, although what I seek to show is, in some ways, this hasn't been dealt with directly as an issue, but courts are actually doing it all the time in some way. So that first part of the book, in a way, suggests that actually there is an engagement with corporate obligations and other non-state actors as well. And yet, this isn't before the court clearly, because we've adopted various obfuscatory doctrines, like the state duty to protect and various others, which in some senses prevent us from seeing that that's directly what we're actually doing. So there's been, in a way, more development in a casuistic way than you know, may initially seem the case, because when one actually looks at sort of direct obligations cases, you're very limited, other than in some jurisdictions like Colombia, which have a significant level of jurisprudence on those kinds of issues, but also to some extent haven't grappled directly with these questions of what kind of model should be adopted. I suppose in some ways I agree with you that on top of this framework, we're going to need to actually, and that's what I see the role of some institutions doing, is we're going to need to go into each right in some ways and understand what the implications are for corporations, as you've correctly said, in each specific area. And that's going to itself be a very lengthy and important project, but one that we know is doable with the state and that will be achieved in a way over time. I think that links with your point about, in some ways, the last point about the kind of traditions. I see, and I know Stephen has written about this, and there's interesting issues about the internationalization of constitutional law and how the modes of reasoning have been expanded across the world and kind of cross various traditions. So in a way, I haven't wanted to root myself in, and my own biases and training may betray themselves in this respect, but I haven't wanted to root myself necessarily in a specific common law, civil law tradition, but really in the broad sphere of reasoning that has developed, that is that commonality that exists across the world. That's perhaps why proportionality is so powerful, right, as a kind of lingua franca that is used across different traditions today. Yes, and so in a way I root my thinking there in the broad structures of reasoning around fundamental rights that will exist at the international level, at the constitutional level, which will find their expression in different ways in different systems, right? And that's why in some ways I didn't want to be overly prescriptive, although it's pretty clear in the book I have a preference for a direct model. I prefer a less obscure, more transparent approach to dealing with corporate obligations. I didn't want to say that this model is inapplicable in situations which adopt an indirect application model or an expanding the state model, because they each can draw on those within their own doctrinal spheres. And I know, and of course respect the fact that legal traditions differ and will draw on their own modalities of reasoning, though, as I contend, there's a kind of universal similarity in some ways, right? And that, of course, is maybe one of the claims of the book and one of the claims which is also contestable. I wanted to engage with your question about balancing, which I think is a really powerful question, and about how can we, in a market-driven economy where there's so much stress placed on the corporation and its own purposes, achieve some objectivity in this regard. And I think it's a real challenge and a difficult challenge. I suppose part of it is, and part of my aim is to start and put the stake in the in the ground with this kind of book, and to start getting these kinds of issues taught, and so legal culture's changing. So there's an educational component as well. Do we as lawyers, when we teach in constitutional law and fundamental rights and international law, do we actually look at these kinds of questions and therefore in a way shift the balance from a balance that's focused purely on commercial interest to a balance that's also going to consider issues which are a more fundamental rights grounding. I also think that the way in which we deal with these issues have to factor in the biases. So I try and do that in some ways, and that's in a way why proportionality, for instance, is useful, right? Because proportionality ultimately has a presumption in favor of rights built into it. It is meant to, in some ways, I'll bracket an issue which I'll come to, but it's meant to, in some ways, at least deal with an asymmetrical relationship, initially between the state and individuals, and I argue between powerful private actors and individuals. And therefore, we place an obligation in many ways on the corporation, a stronger presumption in favor of rights, and a strong obligation to justify any departure from that on the corporation itself. So we, in some senses, jig the system already in favor of rights, although we allow for a justification, but that justification already has to meet certain levels of strength in order to be successful. I think, I mean, that's, as we know, that's not always successful, even in the context of the state, that change of presumption, but I think it's an important procedural tool we can use. And also what I've tried to do by recognizing the complexity of the corporation as involving an individual and societal dimension, whilst I'm very, and we may come to this in some of Stephen's engagement, I know, relating to, you know, purposes, I'm relatively light on how much we look at the purposes in some ways in relation to the corporation, and I allow some general purposes like goodwill, branding, profit making, in some ways to be considered in that context. But then I also want to factor in the balancing that the weights of individual purposes will be reduced to the extent that the social dimension of the corporation is not included in those purposes, or to the extent that the social benefits, the social harms are caused, right? And so that social dimension of the corporation is undermined. There will be less weight placed on the corporation's interests, and therefore less likelihood that there will be an ability to justify the corporation's, the harm that the corporation does. So those are just some, thoughts about how we can try and address that bias, both in the content of what we do, in the procedures and the legal procedures, as well as the wider question, as you say, of the culture that we have to create, which doesn't automatically place the weight on the profit-making motive over and above the ultimately humane-centric ideas relating to fundamental rights. So I think I'm going to give you the chance to come back to me, because I've talked a lot. You know, so we don't run out of time there. And if I have missed anything, you can press me on that.
Right. Well, you know, the next set of questions that arise from that is, can we possibly have a proper recognition of fundamental rights if we continue to consider the corporation as a private person? Now, I know you've written quite a lot in chapter 2, I think it is, in response to Florian Wettstein's ideas, where Florian is actually arguing that the power of multinationals in particular is so strong that they have quasi-governmental power in some situations, and he would argue that this has to then become recognized through the status of the corporation as some kind of quasi-governmental entity. Now, this isn't in itself a new idea. I sort of see Wettstein as a philosophical successor to people like Walter Rathenau, the German politician and philosopher who first considered that the corporation, the large corporation, had become a social entity and therefore should be constitutionalized effectively. And Burley and Means also came to that conclusion because of the separation of management and control in the large corporation. Now, I'm really sitting on the fence with this one, because I happen to think that you're right to say that, you know, let's take one step at a time in a way. We're not going to suddenly jump from the corporation as a private entity that is geared towards private interests straight into turning it into a department of government. And in my own writing, you know, my old piece back in 2001, I stressed the fact that we shouldn't be treating corporations in the same way as public entities, because then they'll be demanding the same kind of public privileges and immunities the state would have in certain circumstances. And indeed also, but maybe we can't escape this. You see, I'm thinking of John Bishop's article in the Business Ethics Quarterly in 2012, where he says that one of the concomitants of actually increasing corporate human rights obligations is that they will ask for certain rights of their own. And I think Jose Alvarez makes this point as well in an article that you've cited. So maybe we're kind of seeing the birth of a new type of understanding of the corporation itself. And there's some hint of that in your chapter 9, where you are talking about fundamental reforms in company law, which I think inevitably would shift corporate purposes towards social purposes and less towards profit making. So maybe, I mean, that's partly why I would say that your book should be read not just by business and human rights people, but by corporate lawyers as well, because I think it's got impacts on the future development of company law, if we think about that.
Peter, I agree with you here fully. I think I haven't made an argument, and I suppose it's possible to make an argument, right? And that would be one of the challenges, is to say that fundamental rights actually requires, in some sense, the dissolution of the corporation itself and the kind of, I suppose, full nationalization of a corporation itself, right? And that would be the far, perhaps, left or socialist perspective. I haven't done that. I'm a little bit agnostic about that. Well, I'm not only agnostic about that, I disagree with it. In fact, I think that, you know, I'm not convinced that the state is always best placed to be involved in the provision of goods, or that we should do away with the market. In fact, the book is not meant to be anti-business. It is ultimately a book which is saying that accepts in some ways some of the premises of the capitalist approach for the corporation, right? And actually says that we can harness individual profit motives in a positive way to achieve certain social benefits, and that the corporation has been incredibly successful in doing many of these things, but also that there's been a runaway with the 1980s, for instance, of the idea that somehow that the private sector, without any regulation, without any recognition of its social impact, will somehow just do good, and there will be, and I'm skeptical about that, given also historical and concrete examples as well. And so in a way, I think the move to really the business and human rights framework and the discussion around business and human rights is really about saying, well, actually, we have these fundamental normative constraints which, in a sense, place the framework within which the ordinary pursuit of business can take place. Now, there may be sectors where it's not possible to do have a private sector consistent with fundamental rights, right? And I think that there's some big debate that we need to have around provision of certain types of services. I'm thinking particularly of healthcare, right? I must say that I think there have also been significant benefits from privatization, but at the same time, I think the way in which patents and our current regimes work around that also land up excluding significant amounts of people from life-saving healthcare. That seems to have got things fundamentally wrong, and we need to debate in some ways whether or not it's possible to adopt the more moderate framework that I propose, which is ultimately about positive obligations plus a restriction on harm to ensure people are able to access with some kind of differential pricing, or whether in fact the entire structure of enabling private sector provision of really important public goods and goods in relation to individuals is acceptable from a fundamental rights point of view. I have gone the former route. I think that's the more realistic route, certainly in our current ideological framework, but I think it is an interesting question and up for debate around some of those questions as to whether that's fully feasible, where corporations seek to take advantage fundamentally of our deep need for the basic goods to survive, and whether we can, how we proceed in that regard. So yes, but I know someone's giving me indications that I need to wrap up. So.
No, that's wonderful. Thank you for those comments as well, Peter. I see Bonnie has a hand up, and I should just quickly introduce you, Professor Bonnie Mayersfield. Wonderful that you can join us, and I know so you're academic at WITS and also human rights lawyer and advocate as well. So it's wonderful that you can be here today and contribute to this discussion. So why don't you go ahead and share your comments and bring you in.
Thank you so much, and I apologize that I wasn't able to join earlier. And I've spoken on about David's book previously, and the more I speak about it, the more I read it, the more I realize that whatever one's view is about his argument, that is going to be the touch point for these discussions. And I think that's the immense success of the book. It's raising amongst others, but it's raising these contentious issues that allows us to actually have a trampoline effect away from the very staid and I think unhelpful debates. Well, they're not unhelpful, but I think they've reached their expiry date, some of the debates. And that's an introductory point I'd like to make about the book. But I really want to follow on this amazing discussion between Peter and David. And Peter, it's great to see you and have always thoroughly enjoyed your work. I wonder, from my perspective and some of the writing that I've done, my view is that we're approaching the question of negative and positive duties from the wrong perspective. It's not a question of whether we should be asking companies, from my view, to be doing more for the sake of achieving social justice and human rights compliance. My perspective is rather that we should be ensuring that companies no longer escape or are no longer allowed to exploit entrenched poverty, inequality, environmental crises to make a profit. So let's contextualize that, for example, in the mining context. You have a mining company that says, you know, I'm going to come in, I'm going to mine, and I'm going to make a lot of money for a lot of people, and all the mine workers who are living in poverty are going to be much, much better off because I'm going to pay them a salary. Now, elsewhere, I've written about how that's actually a mythology. It's not true that that's what happens, but we can press pause on that for a moment. So let's go back to the assertion by this mining company that it is going to make a profit, and it's bringing its resources to this establishment, to this project. At the same time, it contaminates the water, and in response, people get very sick. So there are two ways of looking at this. The one way is to say, look, you knew that there was mining going on, you got the license to do it, and the state must clean this up, right? But we all knew this was going to happen. If you want me to help with some healthcare, I'll build a few hospital beds, but really this is not my domain. The other way of looking at it is, it doesn't matter that we could have foreseen this. I mean, it does matter because it should have been prevented, and usually it's not prevented because of the cost, the cost implications, right? The reality is that why should the exploitation of children, of people living in poverty, of the well-being of such people continue to be allowed to generate profit? That's where, in my view, the negative and positive obligation debate should be taking place. In fact, I think the whole language around negative and positive has this unhappy inheritance of socioeconomic rights, negative and positive discussions from constitutional law. And actually what we should be doing is reinvigorating those concepts to say it's not positive obligations to do things that the government otherwise should be doing, but rather, at least as a preliminary point of view, to take the steps to offset the exploitation of poverty, which is where most of the human rights violations take place. I hardly think that any of the leading CEOs today, other than a handful of women who have probably continued to suffer sexual harassment, are enduring human rights violations. We're talking about people in poverty. So when asking, well, should they have immunity from it? If they were to become quasi-governmental entities and would then have immunity, my answer would be they already do have immunity. There already is the exercise of governmental powers. And in that exercise of governmental powers, they are actually making a continued profit and have created this narrative that we are mere instruments of the marketplace, doing what's good for the marketplace and from the capitalist system, and that doesn't need to be catastrophized in order to pursue this line of thought. But we're doing it and making money at the expense of mass institutionalized human rights violations. So to conclude that, the last point that you made, David, about the reconsideration, in particular the deconstruction of the corporation, is perhaps is, I think, the relevant question, not because I think we need to deconstruct the corporation, because I think we need to understand truly who's writing the story of corporate accountability. The company was started as a colonial project, and it's why today, for the most part, with very few exceptions, the wealthiest actors in the corporate world are white men, and the poorest actors in the marketplace are Black women. It has that colonial context. It has an inheritance of exploitation. So to simply now come along and say, listen, guys, can't you do a little bit more? I think is in fact an incorrect assessment of the status quo. And well done, Dave, on a wonderful book.
Thank you very much, Bonnie. And I think you've, I think you're highlighting almost a different argument to what I make, although some, I do allude to it in the argument for positive obligations as a type of a restitutionary argument, that in a sense, the goal of the corporation, in a sense, the obligations that corporations have, in a way, given past wrongs, as you say, in the past history, and also currently, that there's an obligation on corporations to, in a sense, address those harms that have existed in the past, and that in a sense, it's not just a function of current kind of wrongs, but it's a function of also past wrongs, as well as the very construction of the system itself, right? And it's a kind of deep systemic critique. I mean, I think, you know, I think to some extent, and that is sometimes a critique of fundamental rights discourse, right? That as human rights lawyers, we in a sense work with existing structures to try and improve those structures, whilst not necessarily being able to fundamentally, structurally shift them. I am not totally convinced. I mean, I am, I suppose, more of a reformist than a revolutionary. So my inclination is actually to go the reformist route, and I think some of these things that I've suggested in the book, and the recognition of responsibility and significant responsibility to society for fundamental rights, will actually shift the corporation as well in terms of how we conceptualize its role in society. It will still retain its ability to conduct business and its ability to achieve individual benefits for individuals who invest and individuals who are part of the corporation. But nevertheless, it will also be seen to be part as a fundamentally as a structure that is constrained by social norms, but also contributing in a way to the society as well. And as I said, one of the arguments that I engage with is that one of the arguments for positive obligations is actually, it comes from, in a sense, addressing the harms that the very property system creates, and that as a compensation for the fact that everything today is in a way owned, that everything, in a sense, that the very legitimacy of property rights in a way depends on making space for every individual to be able to realize their fundamental rights. That provides an argument for bodies such as corporations, which have great agglomeration and conglomerations of wealth, to actually provide actively for those who are literally without anything at all. So I don't know if I fully addressed your comments, but I hope at least said things that align to it and connect with it from my work.
May I just respond very briefly to say, yes, you absolutely have. What I want to drive home is that I'm not recommending the revolution as an academic of this forum, as a human being, as a parent, as a member of society. I think the revolution would be fantastic. But from the academic perspective, what I'm saying is it's a subtle difference, but an important one, is that in responding to the visceral fear that comes from the marketplace and corporations about imposing positive obligations, in responding to that, the answer is you are seeing a particular painting, and that painting is one-dimensional and incorrect. But if you look at the globular context in which you're making a profit, it's not actually about an add-on, it's about escaping the accountability. You currently have immunity, and it's correcting that immunity and that impunity.
Fantastic, Bonnie. I think we don't fundamentally disagree, so I'm going to leave it here so we have the opportunity to engage with.
Thank you, Bonnie. I wonder if we could bring in you now, Hannah, and yeah, have your comments. Thank you.
Sure. Hi. Thank you very much for the invitation. And I apologize for missing the first part. They changed the time here in Israel a few days ago, and I completely mixed up the hours. I managed not to do that for the last 2 years of Zoom events, but unfortunately it happened today, so I apologize. But again, I'd like to say thank you for the opportunity to read and discuss this absolutely terrific, extremely important and extremely timely book. I don't think one could overemphasize the importance of David's book, which addresses heads-on one of the most difficult and pressing problems of our time. So I'm not gonna repeat some of the things that have already been mentioned. I completely agree with the argument concerning the growing convergence around the multi-factoral approach and the need to further advance it. I also completely sympathize with the methodological approach taken by the book and the breaking away from the familiar binaries that often characterize the literature and, in my view, limit the discussion. So especially the binary between the normative and the empirical discussion, but also between the national and international levels, between private law and public law, between the philosophical discussion and legal discussion. So it's great to be part of a conversation that sort of breaks away from these binaries. In a perfect world, I would stick only to praising the book because really there are so many additional reasons to praise it and many arguments made in the book that are worth flagging and highlighting. But we're not living in a perfect world, and the format of this event calls for discussion. So I feel obligated to comply and will raise two questions that emerged as I was reading the book. So the first question concerns the distinction between, or the potential distinction between types of individuals with which corporations have different types of relationship and hence perhaps different rights that are relevant for these different relationship and for which corporations should have obligations to protect or to promote. So in chapter 6, the book proposes a general definition of a minimum core or a sufficient threshold of fundamental rights, but I wonder whether some additional distinctions should be made, and particularly with regard to the category of labor rights and whether it should be considered a special category within the general sort of package of fundamental rights. And we can think of several reasons that could justify such distinction between labor rights and other fundamental rights. So first, thinking about labor rights as a special category allows us to distinguish between employees who work for the corporation and other individuals that can be affected by the corporation and their rights can be violated, but they're not part of the corporation. So, for example, customers, as in the example in the introduction part of the book, or the Tandy, right? As she was a customer of the corporation, or in cases of residents who live near, say, the factory and may be affected by pollution problems or noise problems. The relationship between the corporation and employer and the employers, the relationship between corporations as employer and the employees are of different nature and create different set of commitments between the two parties. So such commitments are recognized by labor law employment contracts are considered relational contracts and are different than regular transactional contracts that sort of describe a usual, often one-time exchange of money and goods. Employment contracts create long-term relationship between parties and thus long-term commitment that doesn't exist between corporations and other types of individuals. So this is the first reason. The second reason for focusing on labor rights as a special category is practical. The type of commitments that characterize employer-employee relationship and distinguish it from other kind of relationship is a fundamental principle that is recognized by existing labor law, which even at the very minimum level is shared by all countries around the world. And even when no formal contract exists, employer-employee relationships are often recognized by national courts. So this existing legal basis could serve as an important sort of stepping stone for further development of corporate legal obligations. And I'm thinking here from a strategic kind of practical perspective, it might be easier to advance the set of rights that is based on existing legal consensus. And to a certain degree, this issue is covered by the vulnerability principle or vulnerability factor, but this principle, in the book, this principle focuses on power relationship between the parties and not so much on existing regulations that already recognize a specific commitment towards employees. My second question concerns the relationship between corporations and other non-state actors, and especially other corporations with whom they are linked as part of transnational supply chain or global production chain. And in the introduction, the book claims that it doesn't address global supply chain, but in a way, I mean, the examples throughout the book and in some chapters, there is, of course, I mean, it's impossible to avoid, of course, this aspect because, you know, multinational corporations control half of the world's trade today. So I wonder to what extent the political and economic conditions in which corporations operate within transnational production chains or their status as multinational corporations should be addressed more directly in the definition, not only in the examples or in chapter 10, for example, where you discuss the international institutions that are required to implement the multi-factorial model, but should be discussed more directly in the definition of the various factors that comprise the model, right, the multi-factorial model. In the case of global production chains, domestic corporations that are linked, and for example, I think specifically it is related to the factors of capacity and autonomy. So in the case of global production chains, domestic corporations that are linked to the chain are rarely autonomous, especially down the production chain. Factories are affected to a large extent by demand made by other corporations, sort of further higher up the line, ending at the very top at the brand level. And similarly, the capacity factor should also take into consideration the place of the corporation within the supply chain, whether it's the brand at the top or a subcontractor or subcontractor. So the considerations here may be, you know, complicated because subcontractors may be more directly sort of connected to the individuals, but the brand might have you know, more control or influence and create pressures by setting deadlines, prices, etc., that affect the whole chain of production. So what I'm trying to say is that I think it might be more than just a matter of coordination or content of positive obligations, which are discussed in chapter 8, but rather factors that are inherent to the type of relationship within the production chain or the global supply chain. So thinking about these two issues together, labor rights and the political economy conditions within which corporations operate, led me to think that maybe, I mean, I'm just proposing it, maybe we can think about an additional factor that focuses on relationship, both within the corporation and outside the corporation. Maybe it's something to think about, or perhaps these two issues can be covered by or considered by the set of existing 6 factors in the model that you proposed. To conclude, again, I would like to congratulate David for really taking this brave and ambitious task of writing the book and offering answers to so many important questions. I have many more really great things to say about the book. It was, and especially I want to say, it's a really easy book to read and written in a wonderful way, despite being so detailed and so grounded in you know, in a multidisciplinary discussion, drawing from all these fields of study and presenting a comparative perspective. So thank you very much for writing it, and I look forward to the discussion.
Thank you so much, Hannah, and really appreciate your comments about the book, and also your questions and queries. First on the question of whether like labor rights should be a distinct category or something like that. I suppose I would resist it in some sense, because the book ultimately is attempting to provide a general approach to broader fundamental rights, to dealing with fundamental rights overall. And I would want to kind of ask myself, are labor rights, you know, conceptually distinct from other rights? In some senses they are, right? And I think we need to think about that carefully. And I think that, as I say, again, moving beyond the book, it's going to be important to think about the multi. You're asking, I think, exactly the right question. It's going to be important to think about how the multifactorial approach relates to specific areas of rights and specific regimes. I think what you've put on in both questions, you've highlighted the importance of the relational dimension. And I must say, actually, this is one of the things, perhaps for those writing, how wonderful it is to kind of grow in one's research. And from actually the Colombian case law, I hadn't thought so much about the relational dimension. And they have a very, very kind of wonderful sort of engagement about, ultimately central in their case law is this question of what they call subordination and vulnerability. And they talk about there being certain types of relationships in which there is inherently an asymmetrical power of some kind, and that there's a kind of question mark as to whether obligations are going to arise in that relationship by virtue of that relationship. And then there are actually other relationships by virtue of the factual complex. So they're not specific relationships like the employer-employee relationship, but there's the degree of dependency that arises by virtue of the factual situation that individuals in fact land up in. And they actually are sensitive to those kinds of components. Now, I think labor rights, as you've correctly said, they have a very specific dimension, because in a way, they're often the closest the company holds their employees. In a way, the employees are the, I suppose, an engine of the company in a way, enabling the company to actually, to work. And the company has almost a type of, in some ways, I mean, depending on the structure, almost dictatorial control over the employees themselves. It would depend on the various ways in which the companies are formed. I think there are also very complex relationships, and I try and bring this out a little bit, and I think this is really interesting for social science, of questions of identity in relation to the company as well, and trying to bring out how people themselves often, so you will see people who are totally shattered by the bosses suddenly coming down with them in a ton of bricks, or someone who's like, the dismissal is not just losing a livelihood, but it's a foundational impact on identity in some ways. And so I think that those kinds of relational elements are very, very critical to draw. And I think that it's something empirically, and for more social science, that we need to actually capture those kinds of impacts on individuals in those situations. So I think the relational, as I said, I try and capture it in vulnerability. I would be open to seeing whether that, if vulnerability is itself not enough, whether a broader relationship kind of component would be better placed there. As I said, I was drawing on kind of some existing concepts, but I think those are very foundational to charting the impact. I think, you know, there is also a sort of, as you've said, autonomy is also very much important there. And to some extent, there will also be that countervailing justification that companies will have around the one case that I give, for example, is around a challenge to a company's hiring practices. And it's also in Colombia, and there's a challenge to whether or not the person's entitled to reasons for the particular, for not being hired, right? And these are really interesting kind of cases, and the court ultimately says you are entitled to some reasons, the person was actually given some reason, and that the company had complied with its obligations, but it retains a degree of autonomy over the workforce and who it chooses to employ for its own purposes. So I think, as I've said, I think the framework might well work for labor rights, but it might well be, again, and that's the value of a kind of question you asked of how we drill down into each factor in relation to a specific set of rights. The second point on multinationals, I think is a really interesting one. I suppose it's important just to say, you know, you mentioned that the qualification I make in the introduction. I wanted to have fair and square before us the question of what are the obligations of an individual company. Now, there are lots of debates in international law and in various other, in constitutional law about the obligations of one company in respect of other companies. And you yourself, I know, with your wonderful team of collaborators, have done fascinating work about attributing responsibility to specific companies in supply chains and how principles of attribution. I think those are absolutely vital. They need to be supplemented on top of my account. I didn't want that to cloud me in thinking about the responsibilities of one company in respect of other companies, but trying to just understand, which is a big enough task, I thought, of one company itself. Now, I think you've posed an interesting challenge there, and you said, well, in some cases, we can't actually think about the obligations of one company, even in its by itself, without considering the chain of connections within which it falls. And I think that's an important challenge. And I think I try to take account of that in some senses in the capacity criterion, where I talk about, in relation to negative obligations, the question of the participation in harms that one might participate in, the complicity in harms, the contribution to harms, and as well in positive obligations of the kinds of sharing of obligations that might take place. But I think what you're saying actually is that there may be cases where it's not as simple to simply distinguish the individual obligation from the network of relations within which one falls. And I think that's a good point. I think analytically, it's helpful to have a sense of what the obligations are, and then perhaps open up for those relationships to come into the multi-factorial approach. So I think there are points at which that can enter. And I think, and I hope that would address your concern.
Yeah, absolutely. Thanks.
Thank you, Hannah. I think in the interest of time, we'll jump to Stephen now, and then hopefully we'll have some time at the end for some Q&A as well. So thank you, Stephen.
Thank you. I should begin by apologizing. There's some fairly heavy-duty tree trimming taking place in my neighborhood. So I hope it doesn't drown out what I say, or at least anything of value in what I say. So I just want to also to underscore, like everybody else, you know, what a really important book this is. I mean, it's a very underdeveloped topic of huge importance, and David just does a wonderful job in comprehensively and rigorously analyzing. So I just have a few specific questions, mostly about the nature and scope of the claim of the book. So the first is, you begin with the issue about the drug for breast cancer, and you say at the end in chapter 8 that your analysis leads to the claim that the corporation has a positive obligation to supply the drug at a reduced price that the woman could afford. And so my question really is about the kind of the nature and scope of the claim. Is the claim essentially a moral, a normative claim that has not yet been recognized in law, but you're providing lawyers with a way of making this argument in legal terms? Is it that, on the contrary, this is a claim that is recognized in some constitutional systems, and you're providing a kind of an explanation and justification for the recognition of this claim? Or is it that this is a claim that should be recognized everywhere, that women in this situation have a fundamental right to receive this drug, kind of regardless of the particular constitutional culture and context in which that situation arises? So just some sort of clarification about the nature and scope of the claim would be very helpful to me in kind of thinking about the book. The second, and it's a related claim about the nature of the claim you're making, are the obligations of corporations primarily determined by constitutional or international human rights law on the one hand, or also by private and statutory law on the other? So in some of the analysis, and this goes back to something that Peter said, that there is discussion about how tort law has developed to include such obligations. And you give the example, of course, in India of a statutory duty. But I also have the sense that you're perhaps not satisfied with that, that it's important that these obligations should be seen as constitutional or human rights in nature. And of course, you spend a lot of time arguing for the direct model. It seems to be important that there is a kind of direct constitutional obligation on corporations rather than private or statutory. And so I'd just like to ask you why you think it's important, if that's correct, that these obligations are really constitutional or human rights in nature. The third question is it important, and why is it important, that the claims like that of the woman for the drug are understood as fundamental rights claims? Could one think of these simply as important claims for justice, which are complex, and there are arguments on both sides, and that what you're providing is a framework for reaching the just result, regardless of whether one could think of the claim as being grounded in fundamental rights? And I ask that because when you make your argument for why we should apply proportionality analysis to private actors, you say that this is a mode of reasoning that we use in everyday life, right? When we have complex moral issues which are multi-factoral, we use proportionality to help us even in individual decisions. Of course, we don't there think that fundamental rights are at stake. So the question really is, why doesn't Roche have an obligation to provide the drug, regardless of whether one could think the woman has a fundamental right, which of course raises other issues? Why isn't it just a right, just result using the framework? Why do we need to think there's a fundamental right at stake? And my final question is about the application and adaptation of proportionality to private actors. And I agree with your arguments. I think that they're very compelling arguments about why it is appropriate to apply this analysis. But in terms of how you adapt it, I just have two questions. The first is that you say that what's balanced against the fundamental right are significant corporate purposes. And I just worry that these are too easily available when we think about comparing them with government purposes, right? Typically under proportionality analysis, it's only relatively important governmental purposes that could in principle justify interfering with a fundamental right. But when we're dealing with significant corporate purposes, the purposes are, reputation, branding, corporate autonomy. Those don't seem that weighty in comparison with the types of governmental interests that are used in proportionality analysis. And at the same time, because those purposes don't at least seem to be particularly weighty ones, I think that when we look at the other parts of the proportionality analysis, particularly the balancing, it's going to be pretty rare that a corporation could justify interfering with a fundamental right, except in the case of the most trivial interference, precisely because those purposes don't generally seem to be that weighty when they're in the balance with interfering with a fundamental right. So I just wonder what you think about those questions.
Fantastic, Stephen. Thank you very much for those questions. Firstly, on the status of the claim. So it is a claim. Ultimately, I'm concerned with. I mean, I engage as Hannah said in relation to law, in philosophy, but ultimately these are claims about law, and I ultimately seeking to argue that I suppose this framework is the framework that should be adopted. It was also related to Peter's question. In a way, it's a common framework across the world that can be utilized to explore what the obligations are in relation to fundamental rights and in relation to something like Herceptin, that if the conclusion is that it should be provided at a reduced rate, that is a universally justifiable conclusion, which may, of course, be affected by particular, just like universal human rights can be affected by kind of particular contexts. For example, the right to housing may have different implications in a hot country or a cold country. So also a very wealthy country, there may be less of a case for a reduction in price to a more developed a less developed country. But the argument would ultimately be that the structures of reasoning around fundamental rights lead one to conclusions that are universally applicable. These are also, as we know, these may not have already been fully recognized, right? So the argument in relation to fundamental rights is that, I mean, and we often do that, right? We say these rights imply X, even though X is not necessarily recognized in a particular jurisdiction, and that just jurisdiction is problematic and its law is problematic to the extent that it fails to recognize X, right? And so in a way, this is I say in the beginning, it's a type of a Dworkinian project, that the best understanding of the law, of fundamental rights law, should lead us to reason in this way and come up with certain conclusions around fundamental rights. So whilst it isn't the case that all legal systems recognize, some legal systems do, of course, already recognize that businesses have fundamental rights obligations. Many don't. Many recognize through reason through different structures. They ought to, and that ought is already contained in the laws of many countries around the world and already contained in international law. And so the best understanding of the current existing state of constitutional and fundamental rights law would lead to these conclusions. I know it's a relatively complex position, but I hope at least it gives a sense of what I'm trying to argue in this book. You also argued about statutory law, and constitutionalization. And this, in a sense, I suppose, relates to the previous answer, right? I'm not arguing for everything to just become a function of fundamental rights law. I'm very happy for there to be concrete rules governing data protection, governing privacy, etc., in statutory law. The foundation of those rules, ultimately, in my view, is rooted in fundamental rights, is rooted in the protection of certain goods which are protected by fundamental rights. And if we arrive at certain rules, the basic justificatory basis for those rules is going to lie in the multi-factorial approach. The multi-factorial approach will at times lead to statutory law, it will lead to concrete legal rules. But if we want to go back and say, why does this rule exist? Why is it constructed in this particular way? I would argue that the multi-factorial approach provides that background reasoning in some senses. And given we're in the state of affairs that Peter has suggested we are, and I agree with that, where we're at the kind of infancy of engaging with corporate obligations, we need to, in a way, go back to foundational legal structures to, in a sense, provide us with those more concrete rules, although some do already exist, and I'm not arguing for the repeal of them. Do I think that ultimately fundamental rights should be included in a constitution, or they are already in treaties at the international level, and that constitutions ultimately should recognize their applicability in relation to corporations through whichever modality. Yes, I do, because I think that those fundamental rights interests do in fact have for proper protection, require obligations on the part of non-state actors. And so I think I think the situation in the United States, where it's really difficult at the moment. I mean, although there was a more promising period, which I deal with in the book, where it's very difficult to see the Constitution applying directly to corporations, is a less good state of affairs, and one that I don't have a problem if it's remedied in some ways through statutes. But ultimately, the reason for those statutes lies in the problem that is at the root of this, which is that fundamental rights are being affected by corporations, and therefore require addressing in the legal system itself. I think that also kind of perhaps relates to your question about why fundamental rights themselves. I don't think the whole domain of morality is exhausted by fundamental rights. I think fundamental rights is a subset of the domain of morality, and it's a subset in a way, perhaps, of the domain of justice too. That's an interesting question. Some philosophers would argue once we're in the domain of justice, we actually are in the domain of rights. For example, Mill would argue that. I think that fundamental rights ultimately protect the very most basic fundamental interest that we have as individuals, and I would say that extends to all sentient creatures. All sentient creatures have these most fundamental interests, and as a result, I'm not going to go into the deeper arguments for why fundamental rights exist, but once we recognize the value of those beings, we must accord them certain types of treatment. The book seeks to focus on that rather urgent domain of our moral concern. I don't say that there aren't other areas of our moral concern. There would be perhaps some social goods, environmental goods that don't fall within the domain of fundamental rights discourse. It may well be that the reasoning would apply to them. For example, as I've said, proportionality we can use in daily life in many of our conundrums. So it may well be that in some of those contexts this reasoning would apply. I'm concerned, particularly given the fact that unfortunately there's no priority necessarily that's given to fundamental rights in our world over corporate commercial concerns, to actually highlight that specific domain. I'm very happy for us to consider a wider moral domain as well. But actually one of the problems in a way with prior discourse, and there's a kind of history here, there was a lot of discussion around corporate social responsibility, and it's actually interesting, I think Anita Ramasastry does this, argues about how the change has happened between discussions of corporate social responsibility and moving to business and human rights. And there are some interesting reasons why that's the case. I think on the one hand, there is this kind of common focus of a common morality, the kind of Samuel Moyne's idea of the last utopia, that rights are really the basis on which we can agree on a moral concept that is the focus of our moral concern. And so in a sense, we've narrowed in on fundamental rights as a point of commonality where our moral disagreement is so great on everything else. I think that, and so it's allowed us to actually say, well, we can't necessarily agree on the rest of the domain of morality, but on rights we can agree, and we can at least constrain business within that sphere. Rights, I think, have the benefit of specificity, and I've written about this elsewhere, what I call the individualization of rights, that they actually focus on specific domains. And as I've said, that this book tries to create an intermediate level of an analytical framework, but actually the next step is to go into the concreteness of specific areas. And the particularization, I think, is quite important about the specific wrongs that are done, and focusing on this, on what happens in relation to each specific area. So I think rights help us in that respect. And in your question about the Roche example, do rights make a difference? Yes, I think they do. because I think, Roche could be nice, it could be philanthropic, right? But actually what I'm arguing is that their obligations have the bite of law. They are demands that the women who are suffering from breast cancer can claim against Roche, right? That they can actually make claims which are legally enforceable. And I think that is a central feature of rights. I think Joel Feinberg, it goes back to his work on this, that the claimability of rights is quite central. And that's one of the reasons for in a sense, focusing the discussion on that rather than on sort of just broad moral principles of, well, morally Roche should provide this. I think that's definitely true, but actually I want that stronger bite of the law and the legal domain, and also the normative force of rights, which relates to your last point is, well, what about, now you've got a really strong normative weight on rights. How can corporate purposes outweigh those rights? Okay, and that's a really good challenge. And I try in the proportionality discussion to say, well, we could have this discussion within the debate about what is a significant purpose for a corporation. I'm going to allow us to actually have a broad understanding of what's a significant purpose, because I want to be able to utilize the structure of reasoning of proportionality, which I think is actually useful analytically to think about means end reasoning, alternatives, balancing, rather than trying to do this in a rather unstructured way in a comparison of individual versus social dimensions of a corporation. I think that I think that there are actually examples where we do see the corporation itself as having interests that are of a sufficient weight to outweigh rights. I think Hannah has raised that in relation to in the employment context. There are many rights that are affected in the employment context, which we regularly think, and they're not necessarily trivial, I think, right? Which are restrictions on people's freedom, of movement, of opinion, of privacy, which can be quite intense. We have some of the cases I actually engage with. The stadium ban case in Germany allows for dealt with a situation where private football companies instituted a ban against certain unruly, violent football fans, right? And you might say, well, it's not really that important to people's lives to go to a football match. But at the same time, for these people, actually, this is part of their life. This is part of their identity. This is part of what they find meaningful in life. And they're actually banned for forever going to matches due to their behavior. And actually, they challenge this ban. And in fact, the Federal Constitutional Court of Germany basically says you are entitled to ban them, but you have to provide, you actually have some procedural obligations. You have to hear their side, you have to consider their reasons, etc., and essentially places certain procedural obligations on these parties. And I think there are also some other cases, like the press cases. I deal quite extensively with cases in the book where there's conflicting claims of the press to free speech and privacy or reputation, etc. And there's a complex balancing that takes place, and we actually see that in some cases there's a success. We see in the von Hanover case, which dealt with the Princess of Monaco, with very intrusive photos being taken of her, and we actually see quite different conclusions being reached by the Bundesverfassungsgericht in Germany and the European Court of Human Rights. And so I think that actually it will not only always be a case of triviality where corporate purposes will sometimes outweigh other individual rights. I think there will be complex balancing situations. I do think, and here I do agree with you, there will be cases where the harms are severe, where no possible corporate purpose could justify those harms. And I think that actually parallels the state as well, I think, where there are examples where there are no possible, that the harms caused by the state are so severe to human rights, they cannot at all be justified. And I think there will be similar cases, and many cases of corporate harm will fall into those situations. So I hope I've satisfied you to some extent with some responses to your fantastic points.
Wonderful. We have about 10 minutes, so I think it'd be great to get some questions in there. And as I said before, you can either put your hand up. I see that Hassan has done that, or you can type your question into the chat, and we will read it out. And David and other panelists perhaps can respond as well. But since you've had your hand up, I think from almost the beginning, Hassan, do you want to do your question? Can we unmute it?
Sorry, thank you very much. I'm using actually my brother's account. So my name is Mavish. I actually started work on my thesis of LLM, and the topic was corporate personality and incentive to corporate crimes. I couldn't finish it, and I came to UK and started doing certain other projects, and then started my PhD. But the thing is that I've been, reading all of this material, and it's a wonderful book, a great discussion. I'm so thankful to Professor Peter also for his comments. Wonderful ideas by Ma'am Bonnie. The thing is that are we not really taking for granted this very idea of corporate personality still? I mean, in this era, we are not challenging this very fundamental, principle, because this is also creating a problem. And I meing, how would we, because in Islamic law, for example, I'm from Pakistan, so I have to relate it to this thing, to the Islamic law also. In that, Islamic legal scholars historically explored the idea of artificial personality for non-humans, and they concluded that for the purposes of religious obligations, we cannot cater that. But recently, in 1980, a professor here in Pakistan, he actually explored this idea once again and concluded that Islamic law can accept the idea of corporate personality for corporations, but it wouldn't be a full-fledged personality. It would be a quasi-personality. And ultimately, human beings, especially the board of directors, would be liable for certain things, for certain actions, and the ownership would only be for the shareholders, and they should be responsible for things that usually an owner is. So these are just some thoughts that I wanted to share, and also that are we really not taking this idea of corporate personality for granted in all of this discussion? And one more thing, some people are talking about end of corporations, persons like Elon Musk. So are we ready for that future too? Thank you very much once again. Thank you.
Great, thank you. Is it Maresh, I think? Thank you very much for that question. And I think it is a good question. I mean, you go into the foundations of why are we even discussing this? Of course, the corporation has itself, become an incredibly successful form in terms of most businesses conducted in terms of corporations today. And of course, there is a history to the development of corporate personality. I mean, it used to be, Peter can go into this, I think, in full depth, but there's, royal charters used to exist, and the corporation was a very different entity, and it's evolved. So it's not a natural entity. It's an entity that we have constructed, right? That's something that I try and highlight in the beginning of the book. And why have we constructed its contours in the particular way we have? And part of the challenge I want to suggest, and that's what chapter 9 does, is to partially reconstruct the entity in a way that recognizes what I think is true, that actually the entity must be constrained by the role it plays in society overall. I think what has obviously happened and been shown by practice is that the corporate structure itself is very useful for conducting business, and it is very helpful, right, to individuals, because it creates that separation, it creates the limited liability, so you're willing to take risks. For example, it also separates out the assets, so what's called asset partitioning of the company itself, from the assets of the individual behind it. right? And so, and it creates continuation, perpetual succession. You don't have to relate to whether one person leaves or dies or something like that. It has a continuation and ability. And these elements and these dimensions of the corporation have been very, very useful and effective in relation to actually conducting business. People have been attractive to people and have also brought about many, many advantages. That's the argument, right? At the same time, as you correctly said, that very structure immunizes individuals from responsibility, right? So it, on the one hand, it does that to enable them, in a sense, to invest and to limit their own harms, right, to themselves. And in a way, they're concerned about their rights, right? You used to be able to, if you went bankrupt, you could in the past land up in prison, right? And etc. You could actually, your very fundamental rights could be taken away. So in a sense, to protect you against that, you separate yourself out, but it then allows you to act in ways that are irresponsible, right, in relation to the rest of society through the medium of the corporation. And so I think what I heard you say, and I think this is a kind of exciting area to explore, is whether, you know, and perhaps using constructs like in Islamic law, perhaps African philosophy and other areas, whether there are ideas that can be drawn on which can achieve some of the benefits for business without immunizing against the social harms, right? And in a way, that's partly linked to what I'm trying to do here. I don't challenge the corporate personality per se of the corporation, but the Chapter 9 reforms do in some sense suggest that individuals behind it are going to have to bear some responsibility or be able to, because one's going to have to pierce the veil at times of the corporation in order to ensure that there is actually a seriousness about decision making and the realization of the duties of directors in this area. So as you say, I think we do need to grapple with some of those foundational questions. I've sought to work with what is and modify it in relation also to what is, which is a strong commitment we have in most constitutions around the world, as well as in the international treaties that we have, to fundamental rights, and to actually say that we need to kind of find a harmonization of the corporate structure with those other dimensions of our legal systems.
I'm just conscious, Stephen, that I didn't actually give you an opportunity to come back if you had anything you wanted to say in response to what David had said.
No, my questions are largely informational to just expand on clarifying, but I don't want to take up any time that's left for other people to ask questions.
Sure. David did say he's happy to stay on for another 10-15 afterwards if people are. But we'll unless any other burning questions at this point. I can't see any hands up.
Bonnie wants to reply.
Bonnie, did you have a comment you wanted to make?
Unsurprisingly, David said it much more eloquently than I ever could. So thank you, I don't have.
Well, I think what we can do is perhaps formally conclude, and then anyone who wants to stay on can and ask any more questions. But otherwise, thank you so much to all of our 4 panelists coming from different parts of the world and different time zones. Yeah, really appreciate your comments, and thank you in particular to David for being here in person and continuing this fascinating conversation.